Hello everyone, hope you all are doing well. So today's topic is the Code of Criminal Procedure 1973. So we will discuss chapter wise and section wise. So chapter number 1, Preliminary. So section 1, Short Title, Extent and Commencement. Section 2, Definitions, in which 2A, Bailable Offence, 2B, Charge, 2C, Cognizable Offence, 2D, Complaint, 2E, High Court, 2F, India, 2G, Inquiry, 2H, Investigation, 2I, Judicial Proceeding, 2J, Local Jurisdiction, 2K, Metropolitan Area, 2L, Non-Cognizable Offence, 2M, Notification, 2N, Offence, 2O, Officer in charge of a police station, 2P, Place, 2Q, Pleasure, 2D, 2R, Police Report, 2S, Police Station, 2T, Prescribed, 2U, Public Prosecutor, 2V, Subdivision, 2W, Summons Cases, 2WA, Victim, 2X, Warrant Case. Section 3, Construction of References. 4. Trial of offences under the Indian Penal Code and other laws. 5. Savings. Now chapter number 2, Constitution of Criminal Courts and Offices. So section 6, Classes of Criminal Courts. 7. Territorial Divisions. 8. Metropolitan Area. 9. Court of Session. 10. Subordination of Assistant Session Judge. 11. Courts of Judicial Magistrates. 12. Chief Judicial Magistrate and Additional Chief Judicial Magistrate, etc. 13. Special Judicial Magistrates. 14. Local Jurisdiction of Judicial Magistrates. 15. Subordination of Judicial Magistrate. 16. Courts of Metropolitan Magistrate. 17. Chief Metropolitan Magistrate and Additional Chief Metropolitan Magistrate. 18. Special Metropolitan Magistrate. 19. Subordination of Metropolitan Magistrate. 20. Executive. So 21, Special Executive Magistrate. 22, Local Jurisdiction of Executive Magistrate. 23, Subordination of Executive Magistrate. 24, Public Prosecutor. 25, Assistant Public Prosecutor. 25A, Directorate of Prosecution. Now chapter 3, Powers of Courts. So section 26, Courts by which offences are triable. 27, Jurisdiction in the case of juveniles. 28. Sentences which high courts and session judges may pass. 29. Sentences which magistrate may pass. 30. Sentence of imprisonment in default of fine. 31. Sentence in case of conviction of several offences at one trial. 32. Mode of conferring powers. 33. Powers of officers appointed. 34. Withdrawal of powers. 35. Powers of judges and magistrates exercisable by their successor in office. Chapter 4. A. Powers of superior officers of police. Section 36. Powers of superior officers of police. B. Add to the magistrates and the police. Section 37. Public when to assist magistrates and police. 38. Add to person other than police officer executing warrant. 39. Public to give information of certain offences. 40. Duty of officers employed in connection with the affair of a village to make certain report. Now chapter 5, Arrest of person. So section 41, when police may arrest without warrant. 41A, Notice of appearance before police officer. 41B. Procedure of arrest and duties of officer making arrest. 41C. Control room at districts. 41D. Right of arrested person to meet an advocate of his choice during interrogation. 42. Arrest on refusal to give name and residence. 43. Arrest by private person and procedure on such arrest. 44. Arrest by magistrate. 45. Protection of member of the armed forces from arrest. 46. Arrest how made. 47. Search of place entered by person sought to be arrested. 48. Pursuit of offenders into other jurisdictions. 49. No unnecessary restraint. 50. Person arrested to be informed of grounds of arrest and right to bail. 50A. Obligation of person making arrest to inform about the arrest, etc. to a nominated person, or you can say arrest intimation. 51. Search of arrested person. 52. Power to seize offensive weapons. 53. Examination of accused by medical practitioner at the request of police officer. 53A. Examination of person accused of rape by medical practitioners. 54. Examination of arrested person by medical officer. 54A. Identification of person arrested. 55. Procedure when police officer deputes subordinates to arrest without warrant. 55A. Health and safety of arrested person. 56. Person arrested to be taken before magistrate or officer in charge of police station. 57. Person arrested not to be detained more than 24 hours. 58. Police to report apprehensions. 59. Discharge of person apprehended. 60. Power on escape to pursue and retake. 60A. Arrest to be made strictly according to the code. Chapter 6. Process to compel appearance. So A is summons. 61. Section 61 is forms of summons. 62. Summons how served. 63. Service of summons on corporate bodies and societies. 64. Service when person summoned cannot be found. 65. Procedure when service cannot be effected as before provided. 66. Service on government servant. 67. Service of summons outside local limits. 68. Proof of service in such cases and when serving officer not present. 69. Service of summons on witness by post. B. Warrant of arrest. Section 70. Form of warrant of arrest and duration. 71. Power to direct security to be taken. 72. Warrant to whom directed. 73. Warrant may be directed to any person. 74. Warrant directed to police officer. 75. Notification of substance of warrant. 76. Person arrested to be brought before court without delay. 77. Where warrant may be executed. 78. Warrant forwarded for execution outside jurisdiction. 79. Warrant directed to police officer for execution outside jurisdiction. 80. Procedure on arrest of person against whom warrant issued. 81. Procedure by magistrate before whom such person arrested is brought. C. Proclamation and attachment. 82. Proclamation of person absconding. 83. Attachment of property of person absconding. 84. Claims and objections to attachment. 85. Release, sale and restoration of attached property. 86. Appeal from order rejecting application for restoration of attached property. Now D. Other rules regarding process. Section 87. Issue of warrant in lieu of or in addition to summons. 88. Power to take bond for appearance. 89. Arrest on breach of bond for appearance. 90. Provisions of this chapter generally applicable to summons and warrants of arrest. Chapter 7. Process to compel the production of things. A. Summons to produce. Section 91. Summons to produce document or other things. 92. Procedure as to letters and telegrams. B. Search warrants. 93. When search warrant may be issued. 94. Search of place suspected to contain stolen property, forged document, etc. 95. Powers to declare certain publications forfeited and to issue search warrant for the same. 96. Application to High Court to set aside declaration of forfeiture. 97. Search for persons wrongly confined. 98. Power to compel restoration of abducted females. C. General provisions relating to searches. Section 99. Direction etc. of search warrants. 100. Person in charge of closed place to allow search, or you can say house search. Section 101. Disposal of things found in search beyond jurisdictions. D. Miscellaneous. 102. Power of officer to seize certain property. 103. Magistrate may direct search in his presence. 104. Power to impound document etc. produced. 105. Reciprocal arrangements regarding process. Now chapter 7a. Reciprocal arrangements for assistance in certain matter and procedure for attachment and forfeiture of property. So 105a. Definitions. 105b. Assistance in securing transfer of persons. 105c. Assistance in relation to orders of attachment or forfeiture of property. 105d. Identifying unlawfully acquired property. 105e. Seizure or attachment of property. 105f. Management of properties seized or forfeited under this chapter. 105g. Notice of forfeiture of property. 105h. Forfeiture of property in certain case. 105i. Fine in lieu of forfeiture. 105j. Certain transfer to be null and void. 105k. Procedure in respect of letter of request. 105l. Application of this chapter. Now chapter 8. Security for keeping the place and for good behavior. Security for keeping the peace and for good behavior. Chapter number 8. So section 106. Security for keeping the peace on conviction. 107. Security for keeping the peace in other cases. 108. Security for good behavior from persons disseminating seditious matter. 109. Security for good behavior from suspected persons. 110. Security for good behavior from habitual offenders. 111. Order to be made. 112. Procedure in respect of person present in court. 113. Summons or warrant in case of person not so present. 114. Copy of order to accompany summons or warrant. 115. Power to dispense with personal attendance. 116. Inquiry as to truth of information. 117. Order to give security. 118. Discharge of person informed against. 119. Commencement of period for which security is required. 120. Contents of bond. 121. Power to reject sureties. 122. Imprisonment in default of security. 123. Power to release persons imprisoned for failing to give security. 124. Security for unexpired period of bond. Chapter number 9. Order for maintenance of wives, children and parents. Section 125. Order for maintenance of wives, children and parents. So 126. Procedure. 127. Alteration in allowance. 128. Enforcement of order of maintenance. Chapter 10. Maintenance of public order and tranquility. A. Unlawful assemblies. Section 129. Dispersal of assembly by use of civil force. 130. Use of armed forces to disperse assembly. 131. Power of certain armed force officers to disperse assembly. 132. Protection against prosecution for acts done under preceding sections. B. Public nuisance. Section 133. Conditional order for removal of nuisance. 134. Service or notification of order. 135. Person to whom order is addressed to obey or show cause. 136. Consequences of his failing to do so. 137. Procedure where existence of public right is denied. 138. Procedure when he appears to show cause. 139. Power of magistrate to direct local investigation and examination of an expert. 140. Power of magistrate to furnish written instruction, etc. 141. Procedure on order being made absolute and consequences of disobedience. 142. Injunction pending inquiry. 143. Magistrate may prohibit repetition or continuance of public nuisance. C. Urgent cases of nuisance or apprehended danger. Section 144. Power to issue order in urgent cases of nuisance or apprehended danger. 144A. Power to prohibit carrying arms in procession or mass drill or mass training with arms. D. Disputes as to immovable property. Section 145. Procedure where dispute concerning land or water is likely to cause breach of peace. 146. Power to attach subject of dispute and to appoint receivers. 147. Dispute concerning right of use of land or water. 148. Local inquiry. Now chapter 11. Preventive action of the police. Section 149. Police to prevent cognizable offences. 150. Information of design to commit cognizable offence. 151. Arrest to prevent the commission of cognizable offences. 152. Prevention of injury to public property. 153. Inspection of bait and measures. Now chapter 12. Information to the police and their powers to investigate. Section 154. Information in cognizable offence, that is FIR. Section 155. Information as to non-cognizable cases and investigation of such cases. 156. Police officers' power to investigate cognizable cases. 157. Procedure for investigation. And 158. Report how submitted. 159. Power to hold investigation or preliminary inquiry. 160. Police officers' power to require attendance of witness. 161. Examination of witness by police. 162. Statements to police not to be signed. 163. No inducement to be offered. 164. Recording of confessions and statements. 164A. Medical examination of the victim of rape. 165. Search by police officers. 166. When officer in charge of police station may require another to issue search warrant. 166A. Letter of request to competent authority for investigation in a country or place outside India. 166B. Letter of request from a country or place outside India to a court or an authority for investigation in India. 167. Procedure when investigation cannot be completed in 24 hours. 168. Report of investigation by subordinate police officer. 169. Release of accused when evidence insufficient. 170. Cases to be sent to magistrate when evidence is sufficient. 171. Complaint and witness not to be required to accompany police officer and not to be subjected to restraint. 172. Diary of proceeding in investigation. 173. Report of police officer on completion of investigation. 174. Police to inquire and report on suicide, etc. 175. Power to summons persons. 176. Inquiry by magistrate into cause of death. Now chapter 13. Jurisdiction of the criminal court in inquiries and trial. So section 177. Ordinary place of inquiry and trial. 178. Place of inquiry or trial. 179. Offense trial when where act is done or consequences ensues. 180. Place of trial where act is an offense by reason of relation to other offense. 181. Place of trial in case of certain offenses. 182. Offenses committed by letters, etc. 183. Offense committed on journey or voyage. 184. Place of trial for offense trial together. 185. Power to order cases to be tried in different session divisions. 186. High Court to decide in case of doubt district where inquiry or trial shall be taken place. 187. Power to issue summons or warrant for offense committed beyond local jurisdictions. 188. Offense committed outside India. 189. Receipt of evidence relating to offenses committed outside India. Chapter 14. Conditions requisite for initiation of proceedings. Section 190. Cognizance of offense by magistrate. 191. Transfer on application of the accused. 192. Making over the case to magistrate. 193. Cognizance of offences by Court of Session. 194. Additional and assistant sessions judges to try cases made over to them. 195. Prosecution for contempt of lawful authority of public servant for offences against public justice and for offences relating to documents given in evidence. 195A. Procedure for witness in case of threatening, etc. 196. Prosecution for offences against the state and for criminal conspiracy to commit such offense. 197. Prosecution of judges and public servant. 198. Prosecution for offences against marriage. 198A. Prosecution of offences under section 498A of the Indian Penal Code. 198B. Cognizance of offence. 199. Prosecution for defamation. Now chapter number 15. Complaints to magistrates. Section 200. Examination of complainant. 201. Procedure by magistrate not competent to take cognizance of the case. 202. Postponement of issue of process. 203. Dismissal of complaint. Chapter 16. Commencement of proceedings before magistrates. 204. Issue of process. 205. Magistrate may dispense with personal attendance of accused. 206. Special summons is cases of petty offence. 207. Supply to the accused of copy of public report and order other documents. 208. Supply of copies of statement and documents to accused in the other cases triable by Court of Session. 209. Commitment of case to Court of Session when offence is trial exclusively by it. 210. Procedure to be followed when there is a complaint case and police investigation in respect of the same offence. Now chapter 17. The charge. So part A है form of charges. Section 211. Contents of charge. 212. Particulars as to time, place and person. 213. When manner of committing offence must be stated. 214. Words in charge taken in sense of law under which offence is punishable. 215. Effect of errors. 216. Court may alter charge. 217. Recall of witness when charge altered. So part B. Joinder of charges. Section 218. Separate charges for distinct offences. 219. 3 offences of same kind within year may be charged together. 220. Trial for more than one offence. 221. Where it is doubtful what offence has been committed. 222. When offence proved included in offence charged. 223. What persons may be charged jointly. 224. Withdrawal of remaining charges on conviction on one of several charges. Chapter 18. Trial before a court of session. Section 225. Trial to be conducted by public prosecutor. 226. Opening case of prosecution. 227. Discharge. 228. Framing of charge. 229. Conviction on plea of guilty. 230. Date for prosecution evidence. 231. Evidence for prosecution. 232. Acquittal. 233. Entering upon defense. 234. Arguments. 235. Judgments of acquittal or conviction. 236. Previous conviction. 237. Procedure in case instituted under section 199(2). Now chapter 19. Trial of warrant cases by magistrate. A. Cases instituted on a police report. So section 238. Complaints with section 207. 239. When accused shall be discharged. 240. Framing of charge. 241. Conviction of plea of guilty. 242. Evidence for prosecution. 243. Evidence for defense. B. Cases instituted otherwise than on police report. 244. Evidence for prosecution. 245. When accused shall be discharged. 246. Procedure where accused is not discharged. 247. Evidence for defense. C. Conclusion of trial. So, section 248. Acquittal or conviction. 249. Absence of complainant. 245. Compensation for accusation without reasonable cause. Chapter 20. Trial of summon cases by magistrate. Section 251. Substance of accusation to be stated. 252. Conviction on plea of guilty. 253. Conviction on plea of guilty in absence of accused in petty cases. 254. Procedure when not convicted. 255. Acquittal or conviction. 256. Non-appearance or death of the complainant. 257. Withdrawal of complaint. 258. Power to stop proceedings in certain cases. 259. Power of court to convert summons cases into warrant cases. Chapter 21. Summary trials. So, section 260. Power to try summarily. 261. Summary trial by magistrate of the second class. 262. Procedure for summary trials. 263. Record in summary trial. 264. Judgment in cases tried summarily. 265. Language of record and judgment. So 21A. Plea bargaining. So section 265A. Application of the chapter. 265B. Application for plea bargaining. 265C. Guidelines for mutually satisfactory disposition. 265D. Report of the mutually satisfactory disposition to be submitted before the court. 265E. Disposal of the case. 265F. Judgment of the court. 265G. Finality of the judgment. 265H. Power of the court in plea bargaining. 265I. Period of detention undergone by the accused to be set off against the sentence of imprisonment. 265J. Savings. 265K. Statements of accused not to be used. 265L. Application of the chapter. Now, chapter 22. Attendance of persons confined or detained in prisons. Section 266. Definitions. 267. Power to require attendance of prisoners. 268. Power of state government to exclude certain persons from operation of Section 267. 269. Officer in charge of prison to abstain from carrying out order in certain contingencies. 270. Prisoner to be brought to court in custody. 271. Power to issue commissions for examination of witness in prison. Chapter 23. Evidence in inquiries and trials. A. Mode of taking and recording evidence. Section 272. Language of court. 273. Evidence to be taken in presence of accused. 274. Record in summons cases and inquiries. 275. Record in warrant cases. 276. Record in trial before court of session. 277. Language of record of evidence. 278. Procedure in regard to such evidence when completed. 279. Interpretation of evidence to accused or his pleader. 280. Remarks respecting demeanor of witness. 281. Record of examination of accused. 282. Interpreter to be bound to interpret truthfully. 283. Record in High Court. B. Commissions of examination of witness. Section 284. When attendance of witness may be dispensed with and commission issued. 285. Commission to whom to be issued. 286. Execution of commissions. 287. Parties may examine witness. 288. Return of commission. 289. Adjournment of proceeding. 290. Execution of foreign commissions. 291. Deposition of medical witness. 291A. Identification report of magistrate. 292. Evidence of officers of the mint. 293. Reports of certain government scientific experts. 294. No formal proof of certain documents. 295. Affidavit in proof of conduct of public servant. 296. Evidence of formal character on affidavit. 297. Authorities before whom affidavits may be shown. 298. Previous conviction or acquittal how proved. 299. Record of evidence in absence of accused. So, chapter 24. General provisions as to inquiries and trials. Section 300. Person once convicted or acquitted not to be tried for same offence. 301. Appearance of public prosecutor. 302. Permission to conduct prosecution. 303. Right of person against whom proceedings are instituted to be defended. 304. Legal aid to accused at state expenses in certain cases. 305. Procedure when corporation or registered society is an accused. 306. Tender of pardon to accomplice. 307. Power to direct tender of pardon. 308. Trial of person not complying with condition of pardon. 309. Power to postpone or adjourn proceedings. 310. Local inspection. 311. Power to summon material witness or examine person present. 311A. Power of magistrate to order person to give specimen signatures or handwriting. 312. Expenses of complainants and witnesses. 313. Power to examine the accused. 314. Oral arguments and memorandum of arguments. 315. Accused person to be competent witness. 316. No influence to be used to induce disclosure. 317. Provision for inquiries and trial being held in the absence of accused in certain cases. 318. Procedure where accused does not understand proceedings. 319. Power to proceed against other persons appearing to be guilty of offence. 320. Compounding of offences. 321. Withdrawal from prosecution. 322. Procedure in cases which magistrate cannot dispose of. 323. Procedure when after commencement of inquiry or trial magistrate finds case should be committed. 324. Trial of persons previously convicted of offence against coinage, stamp law or property. 325. Procedure when magistrate cannot pass sentence sufficiently severe. 326. Conviction or commitment on evidence partly recorded by one magistrate and partly by another. 327. Court to be open. Now chapter 25. Provisions as to accused person of unsound mind. Section 328. Procedure in case of accused being lunatic. 329. Procedure in case of person of unsound mind, trial before court. 330. Release of person of unsound mind pending investigation or trial. 331. Resumption of inquiry or trial. 332. Procedure on accused appearing before magistrate or court. 333. When accused appears to have been of sound mind. 334. Judgments of acquittal on ground of unsoundness of mind. 335. Person acquitted on such ground to be detained in safe custody. 336. Power of state government to empower officer in charge to discharge. 337. Procedure where lunatic prisoner is reported capable of making his defense. 338. Procedure where lunatic detained is declared fit to be released. 339. Delivery of lunatic to care of relative or friend. Chapter 626. Provision as to offences affecting the administration of justice. So section 340. Procedure in cases mentioned in section 195. 341. Appeal. 342. Power to order costs. 343. Procedure of magistrate taking cognizance. 344. Summary procedure for trial for giving false evidence. 345. Procedure in certain cases of contempt. 346. Procedure where court considers that case should not be dealt with under section 345. 347. When registrar or sub-registrar to be deemed a civil court. 348. Discharge of offender on submission of apology. 349. Imprisonment or committal of person refusing to answer or produce document. 350. Summary procedure for punishment for non-attendance by a witness in obedience to summons. 351. Appeals from convictions under section 344, 345, 349 and 350. Section 352. Certain judges and magistrates not to try certain offences when committed before themselves. Chapter 27. The judgments. So section 353. Judgment. 354. Language and content of judgment. 355. Metropolitan Magistrates Judgment. 356. Order for notifying address of previously convicted offender. 357. Order to pay compensation. 357A. Victim compensation scheme. 357B. Compensation to be in addition to fine under section 320A or section 376D of Indian Penal Code. Section 357C. Treatment of victims. 358. Compensation to persons groundlessly arrested. 359. Order to pay cost in non-cognizable cases. 360. Order to release on probation of good conduct or after admonition. 361. Special reasons to be recorded in certain cases. 362. Court not to alter judgment. 363. Copy of judgment to be given to the accused and other persons. 364. Judgment when to be translated. 365. Court of Session to send copy of findings and sentence to district magistrate. Chapter 28. Submission of death sentence for confirmation. So section 366. Sentence of death to be submitted by Court of Session for confirmation. 367. Power to direct further inquiry to be made or additional evidence to be taken. 368. Power of High Court to confirm sentence or annual conviction. 369. Confirmation or new sentence to be signed by two judges. 370. Procedure in case of difference of opinion. 371. Procedure in cases submitted to High Court for confirmation. Chapter 29. Appeals. Section 372. No appeal to lie unless otherwise provided. 373. Appeal from orders requiring security or refusal to accept or rejecting surety for keeping peace or good behavior. 374. Appeals from convictions. 375. No appeal in certain cases when accused plead guilty. 376. No appeal in petty cases. 377. Appeal by the state government against sentence. 378. Appeal in case of acquittal. 379. Appeal against conviction by High Court in certain cases. 380. The special right to appeal in certain cases. 381. Appeal to Court of Session how heard. 382. Petition of appeal. 383. Procedure when appellant in jail. 384. Summary dismissal of appeal. 385. Procedure for hearing appeals not dismissed summarily. 386. Powers of the appellate court. 387. Judgments of subordinate appellate court. 388. Order of High Court on appeal to be certified to lower court. 389. Suspension of sentences pending the appeal. Release of appellant on bail. 390. Arrest of accused in appeal from acquittal. 391. Appellate court may take further evidence or direct it to be taken. 392. Procedure where judgment of court of appeal are equally divided. 393. Finality of judgments and orders on appeal. 394. Abatement of appeals. Chapter 30. Reference and revision. So section 395. References to High Court. 396. Disposal of case according to decision of High Court. 397. Calling for records to exercise powers of revision. 398. Power to order inquiry. 399. Sessions judges power of revision. 400. Power of additional session judge. 401. High Court's power of revision. 402. Power of High Court to withdraw or transfer revision cases. 403. Option of court to hear parties. 404. Statement by Metropolitan Magistrate of grounds of his decision to be considered by High Court. 405. High Court's order to be certified to lower court. Chapter 31. Transfer of criminal cases. So section 406. Power of Supreme Court to transfer cases and appeals. 407. Power of High Court to transfer cases and appeals. 408. Power of Sessions Judge to transfer cases and appeals. 409. Withdrawal of cases and appeal by session judge. 410. Withdrawal of cases by judicial magistrate. 411. Making over or withdrawal of case by executive magistrates. 412. Reasons to be recorded. Now chapter 32. Execution, suspension, remission and commutation of sentences. So A. Death sentences. So section 413. Execution of order passed under section 368. 414. Execution of sentences of death passed by High Court. 415. Postponement of execution of sentences of death in case of appeal to Supreme Court. 416. Postponement of capital sentence on pregnant women. B. Imprisonment. 417. Power to appoint place of imprisonment. So 418. Execution of sentences of imprisonment. 419. Direction of warrant for execution. 420. Warrant with whom to be lodged. C. Levy of fine. So section 421. Warrant for levy of fine. 422. Effect of such warrant. 423. Warrant for levy of fine issued by a court in any territory to whom to which this code does not extend. 424. Suspension of execution of sentence of imprisonment. D. General provisions regarding execution. So section 425. Who may issue warrant. 426. Sentence on escaped convict when to take effect. 427. Sentence on offender already sentenced for another offense. 428. Period of detention undergone by the accused to be set off against the sentence of imprisonment. 429. Saving. 430. Return of warrant on execution of sentence. 431. Money ordered to be paid recoverable as a fine. E. Suspension, remission and commutation of sentence. So section 432. Power to suspend or remit sentences. 433. Power to commute sentence. 433A. Restriction on powers of remission or commutation in certain cases. 434. Concurrent power of capital central government in case of death sentence. 435. State government to act after consultation with central government in certain cases. Chapter 33. Provisions as to bail and bonds. So section 436. In what cases bail to be taken. 436A. Maximum period for which an under trial prisoner can be detained. 437. When bail may be taken in case of non-bailable offence. 437A. Bail to require accused to appear before next appellate court. 438. Direction for grant of bail to person apprehending arrest. 439. The special power of High Court or Court of Session regarding bail. 440. Amount of bond and reduction thereof. 441. Bond of accused and sureties. 441A. Declaration by sureties. 442. Discharge from custody. 443. Power to order sufficient bail when that first taken in insufficient. 444. Discharge of sureties. 445. Deposit instead of recognize. 446. Procedure when bond has been forfeited. 446A. Cancellation of bond and bail bond. 447. Procedure in case of insolvency or death of surety or when a bond is forfeited. 448. Bond required from minor. 449. appeal from orders under section 446. 450. Power to direct levy of amount due on certain recognitions. Chapter 34. Disposal of property. So section 451. Order for custody and disposal of property pending trial in certain cases. 452. Order for disposal of property at conclusion of trial. 453. Payment to innocent purchaser of money found on accused. 454. Appeal against order under section 452 or section 453. 455. Destruction of libelous and other matter. 456. Power to restore possession of immovable property. 457. Procedure by police upon seizure of property. 458. Procedure where no claimant appears within 6 months. 459. Power to sell prescribed perishable property. Now chapter 35. Irregular proceedings. Section 460. Irregularities which do not vitiate. So section 460. Irregularities which do not vitiate proceeding. 461. Irregularities which vitiates proceedings. 462. Proceedings in wrong place. 463. Non-compliance with provision of section 164 or section 281. 464. Effect of omission to frame or absence of or error in charge. 465. Finding or sentence when reasonable by reason of error, omission or irregularities. 466. Defect or error not to be make attachment unlawful. So now chapter number 36. Limitation of taking cognizance of certain offences. So section 467. Definitions. 468. War to taking cognizance after lapse of the period of limitations. 469. Commencement of the period of limitation. 470. Execution of time in certain cases. 471. Exclusion of date on which court is closed. 472. Continuing offense. 473. Extension of period of limitation in certain cases. Now 37. Chapter number 37. Miscellaneous. So section 474. Trials before high courts. 475. Delivery to commanding officers of persons liable to be tried by court martial. 476. Forms. 477. Power of High Court to make rules. 478. Power to alter functions allocated to executive magistrate in certain cases. 479. Case in which judge or magistrate is personally interested. 480. Practicing pleasure not to sit as magistrate in certain courts. 481. Public servant concerned in sale not to be purchased or bid for property. 482. Saving of inherent power of High Court. 483. Duty of High Court to exercise continuous superintendence over courts of judicial magistrates. 484. Repeal and savings. So we have completed all sections of CRPC. Go through every section by section and learn accordingly. All the best. Good luck.